and they are complaining a lot of things, not even being in, forget about anything else. They are nowhere, unsuccessful. They secured zero. They secured zero.
Unemployed.
We are at least
Unemployed youth.
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Mr. Bhattacharya, till this judgment is delivered, nothing can be. I will not proceed. But in the meantime, what Mr. Sangupta is suggesting, the recommended candidates in the supernumerary reports, they have their application for admission. If this application is allowed, they are formally been made party. Is there any difficulty?
But they cannot be allowed because there is no right which has yet been accrued in their favor. Lordship knows in the...
Sir, 1 minute. Post has been created, recommendation has been
Yes,
made.
but till appointment is made, Lordship is well aware of the principle.
Yes. No right to the post is created. But ultimately, if the decision goes in your favor, who is the affected person?
None.
The one who has recommended.
No.
We have got the recommendation letter. We have gone to school.
Without even after preparation of a panel, no right accrues unless he is appointed. The settled proposition of law. Today, they are not going to be affected in any way.
No, today, if you are successful in demonstrating that the state has no authority to create, supernumerary report can create, but in the backdrop of the case where it has been done here, cannot be done.
Cannot create. Supernumerary reports cannot be created by the state when there is specific recruitment rules. That is more fundamental question on which will be before the Honorable Court.
But
now,
that is at the instance of people.
Let me say. Now, if these people are allowed to be added, the ultimate aim is that then there will be 500 SLPs before the Honorable Supreme Court.
So what?
That's why you don't have the right.
Where is the bar?
No, Mr. Bhattacharya, supposing I do not add them formally. If they are effective...
Allowed to intervene, I don't mind. No. Allowed to be intervened, argue, it's no problem.
Now, if it is not even added, then also they don't have, then they will not have a right to get and take an appeal against this order.
They have a right to prefer appeal on a leave application. If the Honorable Supreme Court finds that you are an aggrieved party on party. Now, these proceedings will not, in my deepest respect to the Honorable Court and my learned friends, should not be extended to such a situation. This is pure question of law and the jurisdiction authority, apart from the question of the selling of jobs on money.
And at the instance of persons who do not even figure anywhere.
What is the other way around to look into? That you are no way barred from arguing whatever point is available to protect your client. Formal addition or no addition makes no difference.
Makes a difference. For this reason, if I am a party to the proceedings, I can always move out. Supposing, as your Lordship said, go to Supreme Court and have a clarification. If I go to Supreme Court will say you are simply an intervener there. Now, at your behest, we cannot clarify.
For aggrieved party by the decision.
No, aggrieved party is first of all party.
If this is the situation when the writ petition, in whose petition you intend to add, they are objecting. Obviously, they have a right to file an affidavit to that.
We have served these long ago. Your Lordship's pleasure was, I'm instructed by my learned jury to say that your Lordship's direction was call these 201 applicants. Personally see them.
Yes.
And then verify.
Of course, without the person who will be ultimately affected. This is the fire between the state and the petitioner, and you are the casualty. So if that be the situation, you must be hard. There is no doubt about it. I express my... But when the application for addition is objecting, the petitioner is objecting for many other reasons, they are entitled to use an affidavit.
The only thing is...
Let them use an affidavit, short affidavit even. Otherwise, without affording...
Milord, I affirm, I understand, Milord. One might say, without giving any chance of filing affidavit, court has allowed us.
Sengupta, you don't know what stand. Even
I fully appreciate.
vacillating with their stands. So therefore, if you intend to be formally added, you take the pain of using affidavit to these applications. At least to the addition of are there any call the applications number wise? Number wise. Can one of addition of party.
এরা সবাই can. আমরা ছেলেবেলা একটা গান শুনতাম ক্যান
This is Mr. Bari. এখন এই যখন কিছু করা যায়
স্টেট
কিছু বলে আমার কাছে can 2
Yes, Lord.
can 2 can 3
আমাকে ডিলিট করেছো করবে জি তাই
what is the appropriate order? Oh, appointment letter. This is something else.
That's why I told you, Lordship, I'm not aware of what is content of those applications.
Can 4 of 2023 or can 4 will I am pathetic.
What is this?
This is all recommended.
What is this application about?
Application for addition of part.
Addition of এটা আলাদা কর
কত কাম করছে
5 addition ওখানে রাখো 6
And 6 is also an apparently an addition, but they are not appearing today. You have a copy of 6.
দু লাইন করে দেন
6 is are you leading the advocate?
No.
Addition of party.
6 is vacating
6 is a vacating interim order.
আলাদা না
অ্যাপ্লিকেশন করতেই পারে আশ্চর্য
and 7 টা হাতে নেই
একটা ক্লাসিক দিয়েছে অ্যাপ্লিকেশন ডিলিশন করবে
who is a junior in this matter, Mr. Bhattacharya?
মিস্টার সুদীপ্ত দাশগুপ্ত
Mr. Dasgupta use a affidavit to this.
ইয়েস
সবকটা এই
And 2 weeks after Thursday.
Friday after 2 weeks is a holiday.
No, 13th.
ওই পার্টিকুলার ডে
13 or no, the second meet on 20th, and by this time in the Supreme Court declares
Judgment well and good. But Lord, if
yes,
my experience has any value, before May nothing will come because higher secondary examinations are there. Supreme Court will be told that, my lord, now this is interfered with. These persons will lose their job.
There is no scope.
Already told.
হয়ে গেছে 20 তারিখে পরীক্ষা শেষ
already has been told
So they have
that is in anticipation.
No, no.
In anticipation, the higher secondary examination.
What happened to the education system? The Honorable Chief Justice said, don't make this submission before this court. We have done something.
Education
You know, I mean, the education system, my learned friend is saying, the writ petitioners do not even figure in the waiting list.
That's why
They do not even figure in the waiting list.
They
And they
will-
are complaining a lot of things, not even being in, forget about anything else. They are nowhere, unsuccessful. They secured zero. They secured zero.
Unemployed.
We are at least,
Unemployed youth.
we are also unemployed. We are also suffering. We are at the threshold of getting an employment that has been thwarted at their instance.
Must be thankful that without having any scope for getting anything, they are raising.
Paragraphs 1 to 20 centers around allegations which have already been decided by my lord's court.
Yes, CBI, I am keeping this order sheet. Entire bunch of order. কোনগুলো খবর দেখে নেবেন।
what is this?
But be sure and conscious about the objection.
কি ওরা কি বলছে শামীম এই শামীম কি বলছি আরেকটা কি বলবি
My lord, no direction for us as of now, my lord.
Wait,
there is another petition
these are the three other.
only Meenakshi Ghosh we are concerned with.
No, only one.
No. Only Meenakshi Ghosh, Mr. Bhattacharya's writ petition.
These are not related to
ওই
the
তো Mr.
petition.
Meenakshi Ghosh.
Record to inspect করো। Record to inspect করে দেখো, যদি একরকম হয় তাহলে একসাথে ফেলবে, নাহলে ফেলবে।
কি হলো
চেক করে দেখতে বললো যে এক হলে তাহলে সেম সেম অর্ডার হবে নাহলে হবে না।
উপরে দিয়েছেন তো? হ্যাঁ, সবগুলো অ্যাপ্লিকেশন নাম্বার যেগুলো সেগুলো ওই তিনটে বাদ দিয়ে, যে তিনটে বাদ গেল তো নাম্বার গুলো দিয়ে দেবে।